Hi, I'm Scott Engstrom, Executive Vice President and General Counsel here at Kraus Group. And today we're going to be starting our Industry Insights series where I speak with our Compliance Director, Collin Terry, about some new topics and relevant case law and policy changes in the elder law industry. Collin here is going to be discussing with us some recent changes in Massachusetts, specifically a case involving a community spouse. Collin, do you want to kind of go into that case a little bit in the background?
Yeah, so to get started, this case was unique in that it was a shorter term that's typically not utilized in Massachusetts. So to give some background and context, in Massachusetts, the general short-term annuity is not always utilized. Usually 48 plus months would be what we classify as a longer-term annuity. So in this case, we had a $127,000 premium on the annuity with a 2-month term. So again, it was kind of newer to the state where we're using these shorter term annuities. The department hasn't seen them as often. So we had a situation where the caseworker kind of raised a red flag and said a 2-month would not be acceptable. And they attempted to apply a divestment penalty period to it.
I'm going to pause you there because you had mentioned those longer term annuities being kind of those 48 months and longer. Then we talked about the 2-month annuity here involved in this case. But can you give a little bit of a definition about what a short term annuity is?
Yeah, so a shorter term would generally be anywhere from 2 to 48 months. Your larger insurance carriers usually have immediate annuities where their minimum term is usually 4 years or longer. So in general, you're not going to find a immediate annuity that is less than 48 months unless you're working with a specialized carrier that specializes in Medicaid compliant annuities.
Okay, thanks. And could you go, I guess, a little bit more into what the state's theory of the case is on the denial here?
Yeah, the caseworker, again, it was pretty interesting in that their only real argument was that 2 months didn't seem allowed. They really had no justification in law or nothing based in law that they could really point to say why a 2-month annuity wasn't allowed, just that they didn't think it was reasonable.
So it didn't pass the sniff test or the vibe test, basically.
Yeah, so as you know, an annuity has 5 main components to be Medicaid compliant. It has to be irrevocable, non-assignable, actuarially sound, with equal payments, and then also naming the state as beneficiary. So really the only element that comes into play on the term of the annuity would be the actuarial soundness.
Mm-hmm.
That test basically says that the annuity term has to be within the life expectancy of the owner. So by MassHealth's own calculations, the annuity term was shorter than the actuarial life expectancy of the owner and therefore met that test.
And to that point, you said, they didn't just concede on the calculations. They actually conceded that the annuity itself was actually sound in that case, I believe, correct?
Correct, yeah. So that's where it, again, became interesting was that they had no real argument, no basis in law to point to. So there were no case facts disputed. So really, it just became a matter of the fair hearing officer reviewing the case facts and making a judgment call on whether or not the annuity met the MassHealth regulations.
Because when we look at the regulations around the actuarially sound test, that's how you kind of prove that the intent is met, that it wasn't specifically for purposes of qualifying for Medicaid because you're getting that fair market value. And I believe that's from Transmittal 64, correct?
Correct. Yeah. Transmittal 64 was, guidance posted by CMS that basically said there is a ceiling to the annuity terms, but there's no floor. Mm-hmm. So that ceiling, again, being the life expectancy of the owner on the annuity, whereas, again, the floor is basically just whatever the shortest term that insurance carrier would offer.
And so can you get a little bit into what the analysis was in this specific case and how the court came to its conclusion?
Yeah, so the court basically talked about those 5 elements that I previously discussed. They went through and checked all the boxes on the annuity and said, yes, it meets all of these elements. Therefore, the intent test or the sniff test that you talk about does not apply. So the intent behind a normal purchase or a divestment is only applicable if the transaction itself is a divestment. Mm-hmm. Because the annuity met all 5 elements to be Medicaid compliant, the intent test does not apply.
Mm-hmm. And I think while we don't have a United States Supreme Court case saying that there is no minimum term, we do have a pretty well-recognized and well-accepted Third Circuit case, I believe in Zahner, that kind of references that sniff test and also talks about there not being that minimum term. So this decision would be consistent with that understanding and that ruling.
Correct. Yeah. And Zahner is, an example of a case that we often use anytime there's pushback from the department on whether it's the term of the annuity, actuarial soundness, things like that. Like you said, that's a very persuasive decision. We can always reference to say there is no floor on annuities. Fees are not calculated in the return test on the actuarial sound test either.
So then really what it sounds like in this particular case is that the state, because actuarial soundness was established, was adding an additional test beyond actuarial soundness and those 5 requirements, and adding that additional test would have made it more restrictive than federal law.
Yeah, so to that point, again, another good argument of states are not allowed to be more restrictive. That's supremacy clause. So anything that falls outside of the scope of those 5 elements, again, that we talked about, should not be allowed from a federal perspective.
Awesome. Is there anything else more on this particular Massachusetts case that you think is relevant or important for other law attorneys to take away?
I think it sets good precedent to understand that a shorter term annuity is allowable for starters, but especially just given Mass Health decisions on whether or not the state needs to be named as a beneficiary. So as many Mass Health practitioners know, the annuity has to name the state as primary beneficiary in order to be accepted by Medicaid. So with that in mind, we want to use a shorter term oftentimes so that we can avoid state recovery.
Mm-hmm. Okay, well, and moving on to another Medicaid compliant annuity topic, we actually have a couple cases on this one. This discusses what's called the right to cancel or the free look. And we actually have 2 states where this matter was addressed in different ways. We have New Jersey and West Virginia, but I believe, Colin, we were going to start with the New Jersey case. So can you give a little bit of a recitation there?
Sure. So again, to give some background, New Jersey has long taken issue with the free look period on annuities. New Jersey takes the position that if the client can cancel the contract during the right to cancel period, it's a countable resource until that period is exhausted.
And can we actually go and just define what that right to cancel or that free look period is?
Sure. So in the insurance regulations, the annuity requirements say that every policy comes with a free look period, often called right to cancel as well. And that usually varies anywhere from 10 to 30 days. Each state has a different requirement, whether it needs to be 10 days, 30 days. That can also vary if it's a replacement transaction where we're funding it with another annuity or a whole life policy. So that can vary, but the policy will outline whether it's 10 days, 20 days, 30 days.
Okay. And so in this case, it's really about, whether or not, I believe this involved a waiver of the free look form in this particular case. So whether or not a waiver is possible for that free look period.
Yeah, the agency's argument was that the insurance statute requires that any annuity being issued by an insurance company includes a free look period. That free look period, depending on your state, may be somewhere from 10 to 30 days. In New Jersey specifically, there is a 10-day statutory requirement that the client has the opportunity to elect that free look period within the policy.
And this policy did include that, correct?
Correct. So the question really became, did the insurance company meet that statute by including a 10-day free look period? So the argument on our side was really that the insurance company did meet that requirement because the policy did contain a 10-day free look period. And then an extension of that is whether or not the client has the right to waive that statutory right.
Okay.
So when looking at the statute, there's nothing additional in there that says the client cannot waive a free look period. And that's where we went through the process of making sure we filed that form with the proper agency, with the insurance department or the insurance compact that confers that form is valid and approved by the insurance department.
Okay. And that did play into the court's analysis here in this particular case, correct?
Correct. Yeah. I mean, without the analysis of whether or not that form was validly filed through the proper agency, I think the decision would have been different. So the fact that, again, it went through the proper channels, it was approved by the insurance commissioner, they allowed it, that really is what the fair hearing officer relied on to make their decision.
So that's the synthesized rule there that the free look waiver form is valid in New Jersey, and that is a possible way to accelerate that spend down.
Correct. Yep. And again, this is the second time we've gone through that specific issue. So we're hoping that it has been put to bed now. We have multiple fair hearing decisions in which the ALJ ruled that the immediate irrevocable election form, or whatever it may be called with each carrier, is a valid option. Yes.
I think this also illustrates a broader point of how creative some of these state agencies try to get in some of their denials, whether it's a unique issue, a different approach to it. It does seem like sometimes they are trying to, make waves or make a little bit of a change that way.
Yeah, we've definitely seen some interesting outcomes. And again, that's why we're here to give our experience, because a lot of times the issues we face, we've dealt with those 5, 6, 7 years ago. And then we see them rear their head again, and whether it's a new individual within the department trying to take the same issue up, or just somebody who is just erroneously making a decision and not applying the law correctly.
And again, we talked about there being multiple cases where this free look period has been analyzed, but analyzed in a different way. So wrapping up on that New Jersey case, we also had that other free look case that we were referencing out of West Virginia. Can you go a little bit through what that case was about, and then kind of how that is distinguished from the New Jersey case and how a different issue was analyzed within that free look context?
Sure. So like you said, it was a question of whether or not the annuity was countable during the free look period. In this case, we did not have a waiver of free look, so there was no form signed or filed in this case with the insurance carrier. So it really, again, just looked at whether or not the client could cash out and cancel that policy, and whether that constituted it to be a countable resource during that time frame.
So it's really a question about whether this, potentially large chunk of money is an available resource or not.
Okay. Correct. Yeah. So basically the decision came out, and the analysis was whether or not there was cash value during that time, and whether the cash value is separate from the free look period. So in that case, the fair hearing officer did rule that those are two different and distinct concepts, and we don't need to look at the free look period to determine if the annuity is a countable resource. Again, if we look at the annuity rules, it has to be irrevocable, non-assignable, actuarially sound, and naming the state as beneficiary. So in that context, you didn't hear me say whether or not the free look period is still in place. So basically the fair hearing officer said, that is not a test that is required in order to determine if it's a resource or not. So as long as those other elements are met, it is non-countable.
So really, by virtue of there being a free look in these policies, which there's going to be, that does not in and of itself make it an available resource.
Correct. So they basically ruled that as of the effective date is when that money that goes into the annuity becomes non-countable. Again, as long as it meets those other elements, the free look period has no bearing on whether or not it's countable.
Okay. Well, moving on from those free look topics, we've got a little bit of a unique one in our very own backyard here in Wisconsin. We had a little bit of a change of policy, and a policy that some people in other states may not be aware of, that Wisconsin used, kind of related to this valuation of the annuity. Do you want to kind of go into what you guys have experienced in working with attorneys on these types of cases in Wisconsin, and what the, past practice had been before this policy change, or what that policy change actually was?
Sure. So again, to give some background on the issue itself, as many people may know and be familiar with, there is a third-party market out there that will purchase income streams from annuities in exchange for a discounted lump sum. The most common carrier that a lot of people think of is J.G. Wentworth. There's, a lot of marketing done around, again, buying up those income streams in exchange for an immediate lump sum so they can use that cash for other reasons. So taking that in the Medicaid context, in the Medicaid Compliant Annuity context, basically, we had these third parties like J.G. Wentworth providing offer letters on the annuities that were irrevocable and non-assignable. Again, what non-assignable means is that you cannot assign the annuity payments to a third party. So regardless of the non-assignable language in the annuity policy, J.G. Wentworth was assigning a third-party cash value to these policies, even though the owner would have never been able to move forward with that offer, because the insurance carrier would have rejected it because it's not assignable.
And to your point about the insurance carriers rejecting it, that isn't just hypothetical. I believe there was some documentation or correspondence with the insurance carrier indicating that they would not accept the offer, would not move forward on it, despite the offer having been, extended.
Correct. So, again, the caseworkers in Wisconsin, the handbook had given them direction to reach out to these third-party companies to see if there was third-party market value. So when they were getting these offer letters in return to them that said, yes, the annuity could be purchased. However, again, when we reached out to the insurance carrier to verify whether or not they would ever move on that annuity offer, they confirmed in writing that they could not and would not assign the income payments to these third parties because of the non-assignability language.
But I believe the department was not persuaded just by virtue of the letter itself, right? There was some actual proceedings that had to occur.
Correct. So there were a few fair hearings on these issues where, again, we had to go through the analysis of whether or not these third-party offers constituted a cash value where the clients, again, could get out of the annuity income payments in exchange for that lump sum. So after the fair hearings ruled in our favor in that the annuity, in fact, could not be assigned and therefore there was no cash value or secondary market value, Wisconsin reacted to that by providing guidance and regulation changes that confirmed that caseworkers no longer needed to reach out to these third-party agencies because, again, it was kind of a moot point. The offer letters didn't confirm that they could actually sell that policy. So it was creating more problems than it was helping.
So we got to correct it in a couple fair hearings, and ultimately there was a policy memo that changed what the actual policy was. So kind of changed over the course of time through a couple different mechanisms, and then that policy memo kind of put the nail in the coffin of that practice.
Correct, yeah. And I think in the grand scheme of things, that's also what we would call an additional test to the federal rules, right? So again, going back to those 5 elements required for a Medicaid compliant annuity, again, refusal letters saying I refuse to sell this policy to a third party is not an element or a requirement. So again, I think in that context, we would also say that's an additional test that, federal law does not allow. It would be more restrictive and therefore, again, violates the supremacy clause.
Yeah, but that's a common refrain. Again, going back to that Massachusetts case we started the discussion with, again, those more restrictive tests, those things that, may just seem like a policy approach. When you think about them kind of from an intellectual standpoint, they do actually result in, really more people being ineligible and it being a more restrictive practice than is acceptable under federal law.
Agreed. And, there are still a few states that actually require these refusal letters to be submitted with every annuity in order to confirm it has no cash value. So it's not a completely dead practice. Some states do require it. It's only 2 or 3 left that do that. But over time, yes, we have seen some states try to take that position, then it goes away. So it's kind of been back and forth. But again, that's why we go through these processes of fair hearings and supporting the annuity when these issues come up.
And that concludes our discussion here on Industry Insights. So again, I'm Scott, Executive Vice President, General Counsel here. This is Collin Terry, our Compliance Director. And keep an eye out. We'll be having more content coming out. One item that we'll be talking about here in the near future is kind of some of these changes from the One Big Beautiful Bill, how those are impacting and how those are maybe being contemplated in subsequent legislation.